Welcome to this webinar on employee secondment to Albania. My name is Christoph Sturm. I'm the Austrian Trade Commissioner for Albania. Actually, I'm based in Athens, but together with our office in Albania, we are in charge of Albania as well. Before we start, we will wait maybe for 1 or 2 seconds to give everyone the possibility to participate. I think you're aware that this webinar will be recorded, and so for anyone who cannot join, there will be a possibility to see it afterwards. So I think we will still have people coming in. Welcome once again. One question I get asked a lot is why is Albania important for Austria? Because obviously bilateral trade is not that high. But the answer, of course, is investment, because many Austrian companies, more than 50, invested in Albania. And at a certain point, if you invest, there arises the question, you have to send employees to the country. And today we will find, obviously, hopefully find some answers that are going around the topic of employee secondment to Albania. And for that reason, I'm very glad that we could find some real experts in this field. And maybe we could go on to the next slide. It's our experts are 2 lawyers, actually, from Kalo Associates. First of all, I want to welcome Shirli Gorenca, who is partner at Kalo Associates. She leads the employment and labor immigration team. She has almost 20 years of experience in the firm She's advising on employment law, collective bargaining, immigration, and employment tax. She's also an expert in contracts, terminations, work resident permits, and employment tax due diligence. Shirli advises major international and Fortune 500 companies. She has a law degree from the University of Tirana. And also on board, we have Sara Kraja, who is associate at Kalo Associates. She works in the Employment and Migration Department. She advises on employment, migration, social security, healthcare contributions, and deployment and tax matters. She also focuses on resolving employment and tax compliance issues and contributes to tax and customs advice. Sara supports major international companies and collaborates with global immigration or law firms on Albanian legal matters. She has also a law degree from the University of Tirana. So we just for next slide, please, for the questions. Of course, we look forward to having your questions. Just drop them into the chat anytime during the presentation, and at the end, during the Q&A session, we will answer all of them. So do not hesitate, put your questions into the chat, and so that we have a good presentation without interruption. So thank you very much, Shirli and Sara. The floor is yours, and we're very keen to hear what you have to tell us. So,
good afternoon, everyone, and thank you for joining us today. I would like to make a quick note before we start. Today's webinar focuses only on Albanian employment and immigration law, so we won't cover taxes, permanent establishment matters, or other regulatory issues which may have implications but require a separate analysis. In this webinar, we will discuss the main legal options available to companies from Austria that wish to operate or to engage workforce in Albania without necessarily establishing a local entity in Albania. The presentation is divided into two main parts. The first, we will cover scenarios where Austrian companies send their own employees to Albania. And secondly, we will look at situations where Austrian companies engage Albanian-based individuals without having a permanent establishment in Albania. And after this, my colleague Sara will continue with the third part of the webinar, which is on the immigration aspects and permits. In this first part of the webinar, we will focus on situations where a company from Austria needs its own employees to work temporarily in Albania without establishing a local entity. This is very common for project work, technical services, or intra-group support. The key legal issue is how these employees can physically work in Albania while the employment relationship remains with the Austrian employer. So in this main first part of the webinar, we will review the main cross-border models that are typically used in practice in Albania, such as posting of employees, secondment, temporary employment agencies, and some additional flexible or structural alternatives. The first option is the posting of Austrian employees to Albania. In this model, the Austrian employer temporarily sends to Albania its own employees to deliver services to a local client in Albania, while the employment relationship remains fully with the Austrian employer, and the operational control must continue to be exercised from there. Employees may be posted to an external Albanian customer or client to deliver services under a service contract. In this case, the Austrian employer remains the real employer and retains the direction and supervision over the employees. In practical terms, for example, an Austrian company may have sold industrial equipment or technical systems to an Albanian client and needs to send its engineers or technicians for installation, testing, or other related support for several months. So this is mainly the case that is used the posting option. Now, a key requirement is that the posting must be temporary in substance. Typically, it is allowed up to 12 months within a 1-year reference period. And these are cumulative periods. So they can be, then after 1 year, the period will be zeroed and restart again from the beginning. But it is calculated from the first posting. So even without the local entity, the Austrian employer remains responsible for ensuring compliance with the Albanian mandatory labor protections, including working time, leave, health and safety, minimum wage, and equal treatment, unless the Austrian law provides more favorable conditions. And in this case, the Austrian legislation shall apply. There is a short-term exception that for some initial installation or assembly works and services for up to 8 days performed by specialists, the requirements of the Albanian legislation on minimum wage and working time may not apply. But this excludes any construction activities. Now, from a documentation perspective, it is important to issue an assignment letter to each posted employee, and this assignment letter should specify the duration of the posting, the project scope, the reporting lines, the business reason for the assignment, the place where the services will be performed. And this is important because it helps to demonstrate that the posting is temporary and it's service-driven, not employee-driven. Now, the service agreement with the client is also critical. It should clearly provide that services are being delivered and not labor supplied. And it should include indemnification clauses, particularly where the client controls the workplace or the operational environment. Another thing that is important is to extend the employer liability to the health and accident insurance coverage to Albania to address potential exposure during the assignment, because in most of the cases, these persons are not insured in Albania, because it is not a legal requirement generally, because they are short-term assignments. Now, the main legal risk from posting arises if in practice the control shifts to the Albanian client. For example, if the client starts directing the day-to-day work or approving work schedules of the employees, then the arrangement could be requalified into secondment or labor leasing, and this could change the compliance framework. So overall, this model works best for genuine temporary service project where the Austrian control is maintained by the direct employer in Austria. Now, the other option that is applied is secondment. Secondment is slightly different from posting. Here, the Austrian employer continues the employment contract, but the employee is placed at the disposal of an Albanian host entity. The host assumes the day-to-day direction and supervision and integrates the employees into its own organization. Unlike posting, this is not a service delivery model. It is a temporary transfer of workforce where the employee continues to be formally employed by the company in Austria, but operational control shifts to the Albanian host. This structure is typically used where the host needs the employee to be integrated into its operations. For example, when a specialist is sent to support a local team, manage a function, or work directly under the host's management for a defined project. From a legal perspective, the employee consent is mandatory and should be obtained in writing, for example, through an annex of the employment contract. However, the Austrian employer must ensure that the employee benefits from the working conditions equivalent to those of local employees performing the same role. At the same time, the Albanian host assumes responsibility for workplace health and safety and hygiene similar to its obligations towards its own employees. Now, because these responsibilities are shared according to the Albanian Labor Code, joint liability may arise if either of the parties fails to meet its obligations towards the seconded employee. For this reason, a formal secondment agreement is essential. This should clarify the terms of the secondment, the allocation of responsibilities for salaries, compliance, health and safety, and liability, and always include indemnification clauses, particularly covering risks that arise from the host supervision or workplace conditions. Now, in terms of advantages, this model allows the Albanian host to fully integrate the employee into its operations and reduces the Austrian employer's day-to-day management burden. However, there are also risks. The Austrian employer loses the direct managerial control, of course. The compliance exposure is shared between the parties, and the structure requires a genuine host organization with real supervision. Now, overall, the choice between posting and secondment depends on how much control the Austrian employer wants to retain, the duration of the assignment, and whether there is an existing host in Albania able to take over operational supervision. So posting gives more control, but keeps the employer fully exposed for compliance, while secondment shares operational responsibility, but requires a capable host and also may involve the joint liability, which in the case of posting is not expressly regulated by the law. Now, the other option that we have is the temporary employment agency model. Under this model, an Austrian company can temporarily bring its own employees to Albania without establishing a local entity. So this model applies when the Austrian company, for example, has a temporary project or assignment in Albania, but does not want to set up a local subsidiary or branch. For example, an Austrian company may provide technical supervision for a short-term installation project lasting 3 to 4 months. Instead of posting the employees directly, the company can use a licensed temporary employment agency to formally employ these employees locally in Albania for the duration of the project and ensure the fulfillment of the employment obligations towards these employees, while on the other hand, the Austrian company continues to retain its operational control over the employees. The assignments must remain temporary, with a maximum duration of 2 years per employee in the same role. There are also the allowed scenarios and prohibited scenarios of using the temporary employment agencies. The Austrian company's responsibilities include assigning tasks, ensuring equal basic working conditions as comparable employees, complying with health and safety rules, and providing the temporary employment agency with all applicable working conditions so that they can be reflected in the employment contracts of the employees. Now, from a risk perspective, administrative fines primarily apply to the temporary employment agency in Albania if the labor law obligations are breached. Since the Austrian company has no permanent establishment in Albania, the practical ability of the local authorities to impose penalties directly on the foreign entity is very limited. Let's say it cannot be enforced. However, employees may still attempt co-employment claims if they can show that they worked under the operational direction and control of the Austrian company, typically regarding rights relating to equal treatment, working time, health and safety, and so on. And also joint liability may also arise for workplace damage, depending on the allocation of responsibilities in the agreement between the parties. In order to mitigate risks, it is very important to clearly define the roles and responsibilities of each of the parties in the agreement, in the agreement between them, including very strong indemnification clauses. The Austrian company also should avoid taking broader HR functions, such as, for example, dismissal decisions or hiring decisions, in order to reduce co-employment risks. So, in summary, the temporary employment agency model provides a flexible way for an Austrian company that does not have local presence in Albania to temporarily bring its own staff to Albania for projects like technical supervision or project support, and by outsourcing the local employment obligations to a licensed agency, and in this way mitigating administrative and labor risks. Some other structural alternatives are the digital nomad and the independent contractor. Now, the digital nomad option allows an Austrian company to temporarily relocate an employee to Albania while keeping the employment relationship or the service relationship fully under Austrian law. The law specifically requires that the employee has either a valid employment contract with a foreign employer or a service contract with a foreign client, and performs the work remotely without a fixed office in Albania, using IT tools or digital technology. Employees under this model are not considered Albanian tax residents for 12 months, and their presence does not trigger a permanent establishment for the employer, as long as they do not sign contracts or engage in other activities beyond their role. So this is a flexible mobility solution for IT or digital roles, allowing temporary relocation without local registration or integration into the Albanian labor market. And the last structural alternative is the independent contractor. So the Austrian company may engage foreign individuals in Albania as independent contractors. So the foreign individual may be also registered in Albania as an independent contractor, and can be engaged under a service agreement rather than employment contracts from the Austrian company. In this case, the individuals provide services on a self-employed basis, and they invoice the company directly. Now, we will explain this model in more detail in the second part of the webinar. In this second part of the webinar, we move to the opposite scenario. Here, the Austrian company does not send employees to Albania, but instead wants to engage individuals who are already based in Albania. The key constraint here remains the same. There is no subsidiary branch or permanent establishment in Albania. And because of this, the direct employment is usually not practical, as it may trigger permanent establishment risks or local payroll registration and other compliance obligations. Therefore, companies typically use alternative engagement models, such as the independent contractor model, the outsourcing arrangements, and the employment through temporary employment agency, which we already explained under the first part of the webinar. Now let's go through these models and let's see the main legal and practical considerations. Let's start with the independent contractor or freelancer model. In this structure, the Austrian company contracts directly with an Albanian individual as a service provider, meaning the individual invoices for services rather than receiving a salary. This relationship is governed by a service agreement, which is considered in Albania a sui generis civil contract based on the principle of contractual freedom. This means that the relationship is regulated by the general civil law rules and not by employment law, and that the terms and conditions are freely chosen and regulated by the parties in this service agreement. Now, because of this structure, Albanian employment law does not apply, and the Austrian company generally has no payroll, social security, or employment reporting obligations. Also, there is no requirement for the Austrian company to register locally. And on the other hand, the contractor is responsible for registering as self-employed, obtain a fiscal number, issue fiscalized invoices, and pay taxes and contributions. However, there are some limited exceptions where the individuals do not need to register as self-employed. These include non-continuous technical services, occasional advisory or consultancy work, and the other examples that are expressly provided in the tax legislation and are also reflected here in this slide. These exceptions exist precisely because the Albanian law recognizes this as minor or occasional engagements that do not create an employment or self-employment relationship. Now, in practice, some companies may hire individuals directly outside these exemptions. So service contract with individuals that do not have a registration, but this carries risks. Apart from potential employee status claims that these persons may have, there may also be permanent establishment considerations depending on the nature and the continuity of the activities performed in Albania. So these aspects fall outside the employment law, and even although from the employment legislation perspective there is no prohibition, they should be assessed separately under the applicable tax framework. Now, the main legal risk in this model is reclassification. If the contractor becomes economically dependent, integrated into the company structure, or subject to supervision, the relationship would be treated as employment regardless of the contractual wording. From an employment law perspective, where the foreign company has no local presence, the enforcement is generally limited in practice, as it was also mentioned under the other scenarios. And the main exposure is typically potential claims that may be brought by the employees before the Albanian courts, by the individuals in this case, because they are not employees. So to mitigate these risks, the service agreement should clearly emphasize the independent nature of the relationship, and in practice, the contractor should organize their own work and their own working schedule without being integrated into the company's internal structures. Also, when it is required, the individual should be properly registered as self-employed with the National Business Center and comply with the invoicing and tax obligations and formalities, because the absence of proper registration may further support reclassification arguments. Then we have the outsourcing services option. This is when a company contracts a service provider to deliver a defined service using the provider's own staff and resources. So the key point under the outsourcing model is about services and not leasing employees. The provider hires, manages, and supervises its team independently. For example, an Austrian company may need customer support for its products, and it can contract an Albanian provider to run the call center. This is a very used model in Albania, actually. So in this case, the provider would hire and manage its own employees, sets schedules, and handles training. And on the other hand, the Austrian company will only monitor the service quality and will receive reports on the services and work done, but does not hire, supervise, or pay the individual staff. So the role of the user company should always be limited to monitoring the service. It should not get involved in selecting or recruiting employees, in supervising or evaluating them, or handling their salaries or working conditions. If the agreement, the service agreement starts to resemble employee leasing, or if the company exercises too much control over the provider's staff, then there are risks such as claims of unauthorized secondment or co-employment risks. So to prevent this, the service agreement should clearly define the services. The payments should be tied to outcomes or deliverables rather than individual staff salaries. And the company should avoid giving instructions directly to the provider's employees. The benefit of this model is that the provider bears all labor compliance obligations. But on the other hand, the Austrian company has, of course, less operational control over the daily work. But overall, outsourcing allows companies to get the services they need while minimizing employment risks. And the third option is the temporary employment agencies, which we already explained in the first part of the webinar. But here, instead of hiring Austrian employees, the agency hires local Albanian employees and assigns them to the Austrian company. The Austrian company still does not become the employer, and the temporary employment agency handles all employment obligations locally. So to wrap up, Austrian companies in Albania have multiple ways to operate: by sending employees temporarily or by engaging local talent without establishing a permanent presence in Albania. So the choices will always depend on the duration, on the operational control, and whether the presence is temporary or long-term. I will now hand over to my colleague Sara, who will cover immigration requirements for foreign employees, including relevant permits and practical steps. Thank you.
Thank you, Shirli. So on this third part of the webinar, we will be treating entry regulations, or rather, how is work permit or resident permits regulated in Albania regarding the employees that will be coming from abroad to work here under the models that we've discussed with Shirli previously. Just to start off, in 2021, the law on foreigners changed in Albania, so the work permit and the residence permit were combined in one single document, which is called a unique permit. This document, next slide, please. This document is it is at its final form similar to an Albanian ID card, only it is provided to foreigners and it then has a unique foreign ID number. A foreign national will be employed in the Republic of Albania only with a unique permit. So basically, if it's otherwise provided by law or international agreements, they all need to have a unique permit in order to be able to be employable here. With regard to the application, it may be submitted either by the foreigner or their employer and sometimes by a representative, but it's a representative that now must be authorized by the employer or the foreigner himself. And the application itself is also reviewed by different authorities. It is reviewed by the National Agency of Skills and Employment in Albania. It's reviewed by the migration office, the local migration office of the city where the employee will be conducting work. And it's also in the end of the project, of the process, reviewed by the Ministry of Interior Affairs. It should be reviewed within 4 weeks. Sometimes this can vary, but legally it should be reviewed within 4 weeks. We should note that an employer cannot hire a foreigner who is staying irregularly in the country. It may be risking getting a fine by the labor inspectorate if he does otherwise. With regard to US citizens, we need to know that they don't need to apply for a unique permit if they're staying and working for less than 90 days in Albania. And depending on the country of origin, there may be a need to apply for a Type D visa, but this also does not apply for EU member state citizens or for US or UK citizens. The Type D visa will ensure that the citizens, the foreigners that will be working in Albania and staying in Albania can stay here legally for longer than 90 days within a 180 days period. In case of Austrian citizens as EU member state citizens, they may visit Albania for occupational reasons or a project or as an employee or a seconded or posted employee, or even as business visitors or freelancers, but they will not need to apply for a Type D visa as we mentioned above. They will only need to apply for a unique permit if they're staying for longer than 90 days. We've separated here in 4 different categories. The categories of unique permits that could be relevant for the types of employment that will be or can be used in our cases. So with regard to direct employment, there is a unique permit as an employee that is provided as a different special category here in Albania under Albanian law. It will apply if the foreigner will be employed in an Albanian registered company, or it will also apply if the employee is hired under the temporary employment agency model that Shirli presented before. So it is issued to foreign nationals who meet temporary residence criteria and receive prior approval from National Agency for Employment and Skills. This approval is not needed for EU citizens. They are all exempt from that requirement. It is granted for the duration of the employment contract. The main conditions for this type of permit includes that the employer company should be registered in Albania. As I mentioned, it should be registered with the National Business Center. It should have its own tax ID number. But also with regard to the application, the employee that will be applying or the employer that will be applying for this type of unique permit on behalf of their employee will have to prove to the authorities that they have a valid employment contract in accordance with Albanian labor law, and that the employee they're hiring has the professional qualifications that are required for the type of job that they will be conducting in Albania, and also that they have adequate accommodation as is required under Albanian legislation. All applications, as we will present here for the unique permits, are all submitted online through the eAlbania portal, under the unique permit section of the platform. We have different other types of categories that could be used in these models. One of them is also transferred employment, and this is regulated under unique permit as intra-corporate transferees, which could be issued for foreign employees who are transferred temporarily from a company abroad to a group company in Albania. It applies mainly to managers, specialists, or even trainee employees who have worked for the company for at least 6 months prior to the transfer. This will also need some type of proof for the Albanian authorities. And the transfer will need to exceed 90 days for this category to apply. It is granted for the duration of the transfer, so it could be granted up to 3 years for managers or specialists and up to 1 year for trainees. In this type of unique permit, the key categories include the foreign employer to sign a transfer declaration, and the employee should have a valid employment contract and assignment letter by the foreign employer, by the foreign company, specifying the role, the duration, and the conditions of the transfer. The other type of unique permit that could be used here is self-employed residents, which could be contracted as independent people or freelancers. This has its own unique permit category. It's the unique permit as self-employed person, and is granted to foreigners who establish or run their own business in Albania, so they must have their own tax ID number. And it is issued if the activity serves an economic interest, has a positive impact on the Albanian economy, and if the applicant has sufficient capital to implement their own business idea here. It could be valid for up to 3 years, and the permit can be renewable. It could lead also to permanent residence if it's successful for a number of consecutive years. The unique permit as a self-employed person may be limited to a specific activity, region, or profession. And if the profession itself in Albania is required a license for the foreigner or for even the Albanian person to conduct this type of activity, then the foreigner must also comply with the requirement of license, and either will have to convert their own foreign license to an Albanian one or get a new one in Albania. In some cases, in some professions, the foreign license is recognized immediately here, so there's no need for this requirement to be implemented. However, after issuance of this type of unique permit, the holder must notify and obtain approval from the competent authorities for any changes related to their business activity or work or residential address. The key requirements is having to submit a business plan or a project idea to the National Skills and Employment Agency in Albania, and to complete a business registration with the National Business Center, which means getting their own tax ID number in Albania. The special category that also Shirli treated before regarding IT companies is digital nomad. That's also freelancers, falls under freelancers category, but however, they are constricted to a certain line of work, and all the foreigners that obtain or apply for this type of permit can obtain it for up to 1 year if they prove that they have either a valid employment contract or a valid service contract with a foreign employer or a foreign client, and that they should be able to work remotely without having a fixed local office. But they also will have to prove that they have sufficient income to support themselves and their dependents if their dependents are also staying in Albania with them. They must provide proof of contract, adequate financial means and accommodation in Albania, along with valid health insurance for the duration of their stay. Now, in practice, in theory, according to Albanian law, these applicants have some special exceptions which supposedly allow them to apply for this type of unique permit by providing not proof of accommodation or proof of financial means, but a self-declaration of having the accommodation adequate and the financial means adequate. However, in practice, the authorities usually request for these documents to be provided with the application, although the law specifies for unique permits as a digital nomad applicants to only provide this self-declaration and then be able to complete their application by providing the actual proof, the actual documents, within 30 days of their unique permits approval. However, this is, as I said, in practice has not been the case because the authorities usually ask for this proof to be provided beforehand in any case. There's also the last part of transferred employment regulation under unique permits in Albania includes the unique permit for contract services applicants, and this is used when a foreign national it provides services on a temporary basis in Albania while maintaining an employment relationship with a legal entity established outside of Albania that has a service contract with a business registered in Albania. These foreigners will have to have at least 2 years of professional experience in the field covered by the service contract, hold the relevant professional qualifications under the Albanian legislation, and receive remuneration only in connection with the contracted services as paid under the service contract concluded by the employer. This permit, in order to be obtained, requires that both the service contract with the Albanian entity and the proof of professional qualifications relevant to the service be submitted to the authorities along with the application. And with regards to timelines, there's also a special category unique permit, which regulates still transferred employment, but under a shorter period of time than with regard to the other unique permits that we've discussed before. So this unique permit for special categories will treat seconded posted or seconded posted employees or business visitors. And this category covers foreign nationals providing temporary services, as I said, for employees posted or seconded for short-term assignments for typically 60 to 90 days within a year. It can cover business service providers, trainers, technicians, transport staff. With regard to employees seconded for longer assignments, which includes over 90 days up to 5 years, it usually covers technical assistance, consultancy, or project-based agreements. In both cases, the employees may be sent by a group or affiliated company or by a non-related foreign company, and the key requirements remain submitting a valid service work contract or agreement, along with the documents usually required for unique permit applications, which are, as we've discussed with the other categories, usually the same. So for foreign nationals working in business-related activities, they may obtain a unique permit depending on duration and permits, as I said, up to 60 days in a year period. For auditors, business consultants, technicians installing machinery or providing repair training services, and for staff participating in trade fairs or exhibitions. For up to 90 days within a year, cross-border transport personnel, business service providers, trainers under intercompany cooperation programs, and for over 90 days for up to 5 years, this includes technical assistant experts and consultants or advisor under agreements that could be governmental or commercial. There is also one important point that I would like to make here. So I mentioned before that in 2021 the law changed and it provided for the unique permit to cover both work permits and residence permit in Albania, issuing one single document. But in 2025, by the end of the past year, there were other amendments made to the law on foreigners, which aimed to harmonize more the Albanian law on foreigners with the EU law. And these amendments also have a lot to do with EU citizens and strive to facilitate their coming to Albania and staying to Albania and the procedures related to this. So for business visitors or employees posted for less than 1 month, as we talked before, there is no recommended procedures for permission to be granted by the national agency or the immigration authority. However, there is a list of documents that we usually advise to be kept with the Albanian company in order to avoid for the company to get any possible fines from the Labor Inspectorate. When the law changed in 2025, EU citizens were now allowed no longer to, no longer required to submit an application for unique permits, even if they're staying for longer than 90 days, but they were required only to declare their employment status, still online via the e-Albania portal and still through the unique permit application section, but as it was also established even in 2021 with the law on foreigners, they will not need to get any approval from the National Employment Agency in Albania. For people who stay for up to 1 month within 1 year, including people who negotiate agreements or care for a fair work, or for business visitors, they will also have to declare their stay now via the Albania portal. This requirement was not regulated exactly before, but now it's regulated as this, having to declare their status through the e-Albania portal. The declaration form, however, has yet to be approved because we're still awaiting changes to be implemented, applied first and then implemented to the decision of Council of Ministers. And since it's not approved yet, then the same list of documents that we recommend will be applying until the decision of Council of Ministers becomes effective, and then we have an established procedure on how to make this declaration for the EU citizens who will be staying in Albania for up to 1 month and who will have to declare their stay via the e-Albania portal. Now, as I mentioned before, the changes that were made in 2025 to the law on foreigners aimed to establish freer movement, right of movement and residence in Albania, trying to harmonize more with the EU law on foreigners. So for citizens of EU member states and their family members, they can reside in Albania without a residence or unique permit for stays up to 3 months if they're employed, self-employed, or studying, provided that they have sufficient resources and health insurance here. This is especially good and new as a provision for the family members of EU member states, because with this amendment now, family members don't have to be EU member state citizens themselves, but they only have to be members of family with an EU member state citizen who is residing in Albania to be able to stay here and only register their stay without having to get a unique permit or a residence permit under family reunification categories. For stays longer than 3 months, so again, EU citizens must register online. They must declare their employment status if they're going to be employed here. But for staying longer than 3 months, even if they're not working, they must register their stay in Albania with the migration authorities still online, and then they will receive a registration certificate instead of the unique permit or residence permit, which is similar in looks to an Albanian ID card, as I mentioned before in the beginning of this webinar. So after 5 years of continuous legal residence, they may acquire permanent residence with certain categories, able to access permanent residence sooner. Non-EU family members, as I said, also will be able to stay here as residents of Albania under the family reunification residency, but they may also be issued a residence card valid for 5 years or for the duration of their EU citizen family member stay in Albania. And finally, we're still awaiting the decision of Council of Ministers to be approved, as it's currently undergoing public consultation. So we have One final special exemption to treat here with regard to approval and exemptions for national labor and skills agency in Albania. With regard to citizens of EU, Schengen states, the US and Western Balkan countries, all of them do not need to get approval from the National Agency of Employment and Skills in Albania for their employment to be recognized in Albania. They can still just declare their work online via the e-Albania portal. And again, there are specific short-term exemptions, as we mentioned, for business visitors and for other categories such as researchers, trainers, etc. With regard to foreigners and employment and their employment purpose or motive of stay in Albania, they must always adhere to the purpose they stated in their unique permit application, and they should notify the authorities of any changes regarding the employment, their employment, name of employer, place of employment, contract, authorized activities, and also if they change residency, meaning their house or their place of stay in Albania. And finally, this might also be a point of interest. I would like to explain what the difference is with the new amendments made in 2025 regarding the timeline of approval for unique permit applications, because according to the applicable legislation, the residence permit should be approved within a maximum of 4 to 12 weeks. Now, with the 2025 amendments, only 4 weeks, but it's still in practice could go up to 12 weeks, as the authorities have yet to implement the amendments that are provided in the amended law in 2025. Processing time takes longer, but with regard to EU citizens, they have priority, so their applications are treated faster, and I would not see any real issues here with the timeline with regard to EU citizens. However, with regard to non-EU citizens who also have to undergo a visa review process before being able to obtain their unique permits, they are supposed to get their to obtain their visas within 2 to 4 weeks maximum, because in 2 weeks the review process should be done unless there is any problem with their documentation, which it will then get them another 2 weeks to complete the application by implementing either submitting further documentation or completing the information that is lacking in the documents that were submitted beforehand with the visa application. And with regard to their unique permit application, so non-EU citizens, they could go up to 3 months, but they sometimes, in very special occasions, doesn't happen very often, but when it does, it could be inconvenient. It could go up to a longer time. It has gone up to 6 months sometimes. Okay, I hope this covered everything that was in your interest. However, if you have questions, please feel free to ask them to us.
Thank you very much, Sara and Shirli. We have actually 3 questions. I will actually, our time is done, but I will ask for a few minutes more to answer the questions. The first question was about, I'll just read it for the posting notification. Is there a system where we can register our employees, the posting, or is only the assignment letter necessary? If there's a system for posting notifications, is there a legal representative from the customer necessary who has contact with the labor authorities, or does it allow an employee like me who arranges the posting notifications? Thank you. I think it's about if a foreign company posting employees has to notify or register with Albanian authorities, and how.
So in Albania, unlike the other EU legislations, although we have partially transposed the EU directive on posting, there are no obligations for the Austrian company to notify or to make registration of the posting. but it is advisable for the Albanian host company to keep all posting related documents and to prove that social securities and taxes are paid in Austria. From the posted worker aspect, they may need to obtain a permit. And in that case, the registration will be done online. As we said, EU citizens, if the EU citizens working for less than 90 days within 180 days period in Albania, they only will be required to be declared online by their employer through the Albania portal. However, currently this cannot be applicable is not applicable in practice. Until the online declaration process becomes operational. And in this situation, for postings of less than 90 days, we have always consulted our clients to keep a set of documents, like Sara mentioned before, such as the assignment letter, the service contract between the companies, the employment contract with the home company, the official forms that prove that the payment of social securities and health insurance contributions and income tax are paid in the country of origin. And also it is advisable to have an international health insurance policy that covers Albania. So these documents for postings that are more than 90 days, then more than 90 days within a period of 180 days. Currently, they are required to obtain a unique permit, but because the system doesn't work in practice, the online system, but with the changes of 2025, there will not be required anymore a unique permit, and they will be required to be registered online with the migration authority no later than 3 months from the date of their arrival. But there are no obligations to register the posting.
Okay, thank you very much. And then there, I hope this question was answered. And there are 2 questions left for the unique permits. One is European Union citizens, if they stay not longer than 90 days, in which period of time?
Yes, I can answer that. That's no longer than 90 days within 180 days. If they stay longer than 90 days within 180 days, so 3 months within 6 months, then they will need to apply for a unique permit. Within their 90-day stay, they will not need to apply.
Okay.
Yes, but with the changes in the law, this will not be applicable anymore, as I explained.
Yes,
Okay.
I was going to say under current, yeah. Until the changes are implementable, yes.
Yes.
And last question is a new unique permit also necessary if the non-European Union citizens stay shorter than 90 days? It means for non-European Union citizens, if they stay shorter than 90 days,
I think I already replied to this question.
Okay.
It is not necessary to obtain a unique. Currently, they do not obtain anything.
Okay.
Even though the legislation requires that they do an online declaration to the Albania portal, it is impossible to do that in practice. So currently they do not obtain any type of permit, and they need to keep that set of documents. I mean, not only them, but mostly the host employer in Albania needs to have that set of documents in case they are inspected by the tax inspectors or the labor inspectors.
Okay, thank you for clarifying that once again. Yeah, I think we can wrap it up now with this because there are no further questions. I thank you very much for being with us and sharing your knowledge with us. I would also like to take the opportunity to point to some events that we will have in the near future. We have our next webinar on the 4th of March with the best Balkans in focus, developments and opportunities. This will be a webinar in German, which will cover all West Balkan countries, new developments, and so on, with my colleagues from the other countries. On the 23rd of April, we have a big conference, Austria Connect in Bratislava, which will not only cover Southeastern Europe, but also Eastern Europe, from Poland to Romania, all the countries. 22nd to 24th April, we will participate at the Trade Fair Agriculture Days in Luzhny. And 6th to 8th May, we will have a trade mission to Škoda and Tirana for education and recruiting. And looking very far ahead, in October, we will have a trade mission, infrastructure and construction on Albania. And on the 3rd to 6th November, we will participate at the Tirana International Fair. So that's just to give an overview. I thank you very much for your participation, for your expertise. And if you have any other questions, you can either write to us or maybe also write to Shirli and Sara, and we'll be happy to answer. So thank you very much for participating, and all the best. Thank you.